finally now the Gore team is talking more than ever about that case in Seminole County involving disputed absentee ballots. The Gore campaign is not a party to that lawsuit, but they are now out there very aggressively making the point that that suit, should it go in their way, in the way of the people that are sympathetic to Vice President Gore in terms of throwing out those disputed absentee ballots, that would be more than enough votes to sway the election for Al Gore. So certainly the Vice President, they are saying, not going to entertain any discussions of conceding this election until those three developments have run through their full course. Gene.
Jonathan, stay with us for just a second. Let's go back to Gary Tuchman in Tallahassee inside the courtroom. Gary?
Gene, I just talked to Kendall Coffey, the Democratic lawyer who you may recognize from the Elian Gonzalez case, who's now standing at the podium. He has told me he will not be bringing up that Fifth Amendment issue situation that he just brought up a short time ago. He met in the back with lawyers from the other side, and he won't tell me why he came to that conclusion, but he says that won't be brought up again. What just happened a short time ago is he was cross-examining Thomas Spargo, who had been testifying for the Republicans, and he said, isn't it true that you took the Fifth Amendment many times in a previous case? That's when the case stopped. I went up to Spargo, who was standing near the witness, who was sitting at the witness stand right now. I asked him what that was all about. He says, let's wait and see what happens. A source here tells me it was involved in he's from Albany County, New York, and there was a case in New York State involving election law, and that's where something like this happened. In other related news, Dexter Douglas, one of the attorneys for the Gore team, just told me that he is now confident that they're going to win this. He believes that the judge will rule that those 9,000 disputed votes, at the very least he says that those 9,000 disputed votes in Miami-Dade County will be counted by hand. The Gore team is very happy with the way things are going today, but we should point out that the Bush team says it's also happy with the way things are going today. So, of course, what's what we expect to hear, but everyone has their little spin on the way things are going today. Gene?
Gary, what a surprise. Lawyers for the two sides predicting victory. Jonathan, Carl, do we expect to see the Bush camp, or the Gore camp rather, this week produce more pictures that show the Vice President involved in transition?
Well, the position that the Gore team has made on that question is that anything right now, before we hear something out of either the U.S. Supreme Court or something definitive out of Judge Saul's courthouse, anything in terms of transition is merely a sideshow. They looked at what Governor Bush was doing in terms of meeting with his transition team, meeting with the Republican leaders out at his ranch, as exactly that, as a sideshow. So yes, you know, the Vice President has been doing the very same meetings, but up till now, and at least until we hear something out of that Leon County courthouse, we don't expect to see them invite the cameras in so that we can all see those meetings going on. But they are very much going on. The Vice President doing every bit as much in the way of transition as we're seeing happen down in Austin.
Tony Clark, you still with us?
Yes.
Is that ranch in Crawford a media-free zone?
Very much so. I mean, there is news media that is on the periphery, but if you drive around the ranch area, there are signs that say no stopping, no standing there. And that's one of the reasons I think the governor wanted to get to the ranch, is he gets away from the cameras that encircle the mansion, gets away from the crowds that are here, and allows him the chance to sit down, as he did yesterday with the Republican leadership, sit down and talk free of any disturbance. And so Tony? It's a very small area, and yes, pretty much media free.
Could he get cable there if he wanted it?
Well, I don't know if he could get cable, but he could certainly get a satellite dish.
Tony Clark in Austin, thanks very much. In a moment, Kenneth Gross, they tell me to go to you now. The issue of credibility and what's happening in that courtroom at the moment. Talk about that.
Well, I think what happened were sort of two things. One, the Gore lawyer wanted to impugn the credibility of this witness, apparently based on the fact that he pled the Fifth Amendment in another case, and now has agreed not to raise it.
In a related case?
No, as I understand it, perhaps some case in New York totally unrelated to this, and they have agreed in a recess not to raise it. Probably for two reasons. One, this is not a jury trial. Those types of things work better in front of juries than judges, number one. And number two, he's already made the point. He's kind of thrown it out there that there's this Fifth Amendment issue, and they had a hubbub and a recess, and now they can move on and not make anything more of it.
I understand that Kate Snow in Tallahassee has a bit more background on this. Kate, educate us.
Yeah, Gene, Gene, just to tell you what this is all about, referring to Thomas Spargo, the gentleman who was just on the stand, what they may have been trying to raise, what I expect they were trying to raise, is in 1986, Spargo, who was at that time counsel to the Republican State Committee of New York State, living up in Poughkeepsie in the Albany area of New York, he was a target of a special state commission. He was accused of funneling campaign funds from a shopping mall developer into the 1985 local elections in Poughkeepsie, New York. This from a New York Newsday article from 1996 when he was working for Bob Dole. Spargo fought those charges for 4 years. He was never criminally charged, and he did plead the fifth when he appeared before that state commission that was looking into these charges that he had funneled campaign funds. Again, he was never criminally charged, but he did plead the fifth in that case. So I suspect that that is what Kendall Coffey wanted to raise as far as his legitimacy, as far as his credibility. Let me turn to David Cardwell, if I can. That's what they're trying to do. They're trying to shoot down this witness who's done a lot for the Bush side.
Yeah, it's called impeaching the witness, and that's when someone who's been on the stand for the other side has really done a good job, and you want to try to undermine the effectiveness of their testimony. You can go after not only what they said, whether it was factual or not, but their credibility. Has there been some other instance where their veracity has been challenged, or they've been charged with some other offense? So what if they were going to go down this road, they were going to be attacking credibility. Also interesting is that this is the first dispute that we really had in this case. First real friction. I mean, there's been some give and take back and forth, but for a case of such importance and with the tension running so high, really this has been a very civil proceeding so far.
And we at this point should have one more Bush witness, if my count is correct. Right. We should have one more to hear from. Perhaps one of the interveners will then step in with one more witness after that.
That's right.
Okay,
Kate
thanks very much.
David,
back to you, Gene.
And Kate, thank you. Very good timing. The judge is back on the bench in that courtroom.
That took place as well, weren't there?
Yes.
And in fact, we can get this. I want to call your attention to the photograph behind you, Mr. Spargo, and ask if that's you.
Yep, that's me sitting there in my blue jeans.
Okay, and I gathered that you're part of a group of demonstrators. Does it appear to be, sir?
Actually, I was there as an observer on the 19th floor.
Right.
And the people around there were observers as well, several whom I see are lawyers.
Yes, sir. And were you holding your hands for any particular reason, or does it appear that you were clapping and chanting and sort of yelling together, correct, sir?
Yes.
Okay. And in fact, that sort of event is what took place between the morning meeting on Wednesday, November 22nd, when the canvassing board chose to go to a manual recount of all the undervotes, and the afternoon when it was shut down, correct?
Excuse me, this is beyond the scope of
Your Honor, if I may.
He's on cross. I'll give him some leeway.
That's the kind of thing that was going on throughout that time, right, sir?
That was the time period that
right.
You're describing.
And you were present, weren't you, when Supervisor Leahy and the others said that they could do a manual recount of the undervotes and do them at a rate of 300 an hour. You were present for that, weren't you?
He did describe a rate, and if that's the rate that he indicated, I think he also had so many per minute as well, and I don't remember what the exact number was.
Okay. And so in the morning, with Judge Lair and Judge King concurring, with the information of the Supreme Court fully available to them, and with the canvassing board members themselves planning on doing the recounting, they said they would get it done in time and they would do it at the rate of 300 an hour, right?
I'm not sure that I heard that. I heard that they stated the rate at which they would have to go forward in order to succeed, and I'm not sure that they were even able to conclude that they would be done by Sunday.
Okay. Well, let me just show you then, if it'll refresh your recollection, page 14 of the transcript of November 22nd, 8 a.m. And toward the bottom of it, beginning at line 19, are some statements by Supervisor Leahy. Does that refresh your recollection, sir, about the fact that in the morning, and I could show you another page where 300 an hour is also stated, that they'd have to move.
Yes, sir.
But that they could get it done at 300 an hour, right? Does that refresh your recollection?
That refreshes my recollection that there had to be some rate of accomplishment under a very tight timetable to accomplish that.
Mm-hmm. So if I say I think it's doable, I think we can accomplish it, it refreshes your recollection that the canvassing board determined in the morning for this and other things that it would get done on time. The undervotes only, right?
That was what the record states.
Okay. And obviously we heard before, we all know what happened in the afternoon. We shut down. I want to back up a little bit and talk about this discussion you had about Chads falling out and things like that. Now you recall, sir, that these issues of why you couldn't proceed with a computer-generated separation were brought to court in Dade Circuit Court no less than 2 different times. You aware of that?
I'm aware of it because you're telling me so.
Okay. Well, it was in the newspapers that the Republicans, and you were involved with the team, went to court Saturday night. Does that refresh your recollection? Okay.
We need questions and not statements.
Okay. Do you recall the fact that the Republicans went to court Saturday night to challenge the separation process and other things that you have described here in court before Judge Sauls today? Do you recall that?
I'm not aware of that.
You had no awareness that they went to court on that weekend?
I just arrived. If we're talking about the 18th, I had just arrived that afternoon in Miami, so I was not aware of that.
Okay, well, what about the following Tuesday? You're aware that the Republicans went to court that morning, aren't you?
Sir, I was busy enough focusing on my responsibilities of watching the process without worrying about what other lawyers were doing and where they were going to court.
Okay, my question really was, were you or weren't you aware of the fact that the Republicans went to court on Tuesday morning after having been previously rejected by one Dade Circuit Court before another Dade Circuit judge to challenge the procedures for separating the undervote ballots that the supervisor of the elections was undertaking?
I'm not aware of that.
Not aware of that. Okay. And if I were to walk forward and show you copies of pleadings, that would not refresh your recollection?
No.
Okay, I'll save the time on it. Now, by the way, you're obviously based in New York, is that right?
That's correct.
And New York, I think they vote with machines that use levers?
Lever machine generally, and some in many counties use now a punch card system in their absentee ballots.
Okay. And in New York, you seem to make an issue of the fact that only the Elections Department personnel were handling the ballots?
That's what I observed here,
okay.
And I think under New York law that's required, but
okay. In Florida, though, isn't it true that absent an order, for example, from Judge Sauls, that the only folks who could physically handle a ballot would be the staff of the Elections Department and the canvassing board members? Is that true?
That's true.
Okay. Why then, a little earlier, did you indicate in response to Bush questioning that you were troubled by that they wouldn't let you handle the ballots?
I don't know that I was troubled by the fact that I wasn't allowed to handle the ballots.
Now, you're not a Florida lawyer, so you're not aware of case law such as Spradley versus Bailey, First District case, anything like that, correct?
That's correct.
Okay. And let me see if I have any more questions.